morning, everyone. Happy Lunar New Year. 恭喜发财，恭喜发财. So happy to see you today. Welcome you joining today's class. Savor at home and learn. Natural hazard disclosure and the phase 1 environmental site assessment process. What's differences and similarities? I'm Pauline Lam of Cotai Realty, your 2021 co-chair education committee, Western Gabriel Valley Realtors. A friendly reminder, all participants will be muted, and should you have any questions, please enter it into the chat box. Sylvia will help you to address the question during the Q&A session, and speaker will answer your question at that time. The session is being recorded and will be available on the YouTube channel, Western Gabriel Valley Realtors. Now, I'm so happy to have Sylvia Rosish, our Education Committee Co-Chair, and to introduce our special speaker, Mr. Ami Adini and Mr. Stephen Strickland. Sylvia, the floor is yours.
Thank you. Good morning, everyone. Welcome to our second Safer at Home and Learn event. Please keep posted for all events that are coming once a month. Remember, it's the third Tuesday of the month. And today we have our natural hazard disclosure and phase 1 environment site assessment process, different and similar by Ami Adini Environmental Services and Stephen Strickland, First American Natural Hazard Disclosure. Our first speaker will be Amin Adini. Good morning, both you, Amin and Steve, and welcome to our February event. Amin, let's get you started. Everyone knows about you. You are one of our members, and you have great information to cover today for us.
Well, thank you very much, Sylvia, for the introduction. And as a matter of fact, what we'll do is Stephen will talk first about the natural hazard disclosure. And then I will move in after about 45 minutes, and I will explain the phase 1. And it will be much easier for me later on. You see, I'm kind of a lazy guy. I want Stephen to do the hard work, and he will do the NHD. And then I will move in and I will explain the phase 1 and show the differences between the phase 1 and the NHD. So with that said, Stephen, why don't you take over and start sharing your screen and go for it.
All right, that sounds great. Thank you, Ami. I'll go ahead and get into my PowerPoint here. And I think I heard Ami say that he's lazy. I would disagree. I've seen how hard this guy works. We've had conversations at 10 o'clock at night. He's a very hard worker. Okay, so can everybody see my screen? Again, my name is Stephen Strickland. I'm the Regional Manager and Commercial Specialist with First American Natural Hazard Disclosures. It looks like someone's coloring on my, Peter, you're coloring on my PowerPoint. That's okay. That's okay. You're just making it look better. That's all right. I'm okay with that. Okay. So your local representative for First American Natural Hazards when it comes to residential and commercial is Brandon Sarvansky, and I believe he is on this call. Brandon, if you can input your information into the chat box just so everybody has it, that would be great. Okay. So let's go ahead and we're going to get started. Let me see here. Hold on one second. I have Spectrum Internet, so if you guys have ever used it, you know that it's not the best. My goal today is really going to be to let you know what the purpose of the NHD report is in the world of commercial transactions. We're going to take a virtual field trip and talk about the natural hazards that are going to affect our business area. We're also going to talk a little bit about a phase 0 report, what that is and how that complements the phase 1 and phase 2 reports. So first question I have is, do I need an NHD for commercial transactions? Well, let's focus on California Civil Code 1103. That's going to mandate disclosure of specific natural hazards covering flood, wildfire, and earthquake-related hazards. So the mandate applies generally to the transfer of all real property. So at face value, that's going to include the commercial property. So two authorities that agree with this are the California Association of Realtors 2020 and 2021 sales disclosure chart, as well as the California Bar Journal article titled New Natural Hazard Disclosure Requirements. We'll actually go through these right now. So if you haven't seen this before, this is the CAR Risk Management Sales Disclosure Chart. Actually, at the top, I have that link there that would take you directly to it. So as you can see, it's telling you what you need and when you need it. So let's look at this here. So here we go. About, what is it? 1, 2, 3, 4, 5 over or around that that highlighted circle there. It says commercial and industrial / vacant land for natural hazards. So when it comes to disclosing it, it's saying yes. If you see that there, area of potential flooding does need to be disclosed. Earthquake fault zones, yes, it does need to be disclosed. Special flood hazard areas and state responsibility areas such as fire hazard areas, yes, they need to be disclosed. And very high fire hazard severity zones, they would need to be disclosed as well. The interesting thing is residential sales, for those of you that do a little bit of residential and commercial, require the statutory NHD page, but commercial sales do not. So we find that kind of interesting that yes, you're required to report out on all of these specified natural hazards, but you don't have to get a signature for it. That's kind of different, right? Why wouldn't you want to get the signature in my mind? So law says you don't have to, but to protect yourself and to protect your sellers, I always recommend anything that you give to the potential buyer to make sure that you get some sort of signature receipt. Do I need an NHD for commercial? Let's talk about the California Bar Journal here. Hold on, let me go back, sorry. California Bar Journal says the disclosure requirements apply to all real estate transactions, including the residential resales, new subdivision sales, and commercial property transactions. So failure to make the required disclosure may render the seller or the seller's agent liable for those actual damages suffered by the buyer. So here's the California Bar Journal, as you can see. And I don't know if you can see it because Peter's pretty little artistic ability there is covering some of it, but you can see California involving both residential and non-residential. It's talking about the different seismic hazard zones, high fire, high severity wildland transactions, and then the failure to make the required disclosure may render the seller and seller's agent liable for any damages. So who must make this natural hazard disclosure? The seller's agent has the primary responsibility to make the disclosure. And what happens if the disclosure is not made? Failure to make the required disclosure will not invalidate the transaction, right? Because we see a lot of the transactions go through anyways. But however, any person who willfully or negligently fails to make the required disclosures is liable in the amount of actual damages to the transferee. Now, everybody here knows who Gov Hutchinson is with CAR, legal counsel. I was just on a call with him not too long ago, and he actually said almost 90% of real estate transactions that fall into a litigation or lawsuit are because of lack of disclosure. Lack of disclosure. So he said, when in doubt, disclose, disclose, disclose. You know, a funny fact that actually came up. How many, I'm just kind of curious, and anybody can answer this. How many realtors, so state licensed realtors, are in the state of California? Any thoughts? Close to about a little over 200,000 state licensed right now. But how many attorneys are licensed in the state of California? About double. About double. It's unbelievable. So, you know, right now, what is a real estate agent to an attorney? and I hate to put it this way, and hopefully there's no attorneys on with us, and I don't mean to I'm not trying to badmouth anybody here, but an attorney often or some could look at a real estate agent as a easy settlement, right? Because you as the real estate agent don't want your name to be associated with any kind of lawsuit or litigation when you do a Google search for this real estate agent. So it's important to make sure that we are following the law. Okay, so do I need an NHD for commercial? Yes, you do. But do I need the signature page of the NHD? No, you don't. The page is not a statutory NHD requirement for commercial. Whether this acknowledgement of receipt must be signed in a commercial sale is really a decision best made by the parties and their legal counsel. Again, consult with the broker, consult with your legal counsel. I personally just recommend getting anything, a receipt on anything that you're going to give over to the buyers. Okay, so that is the natural hazard disclosure statement. You can see where it says signature of transferor and signature of transferee. That would be the seller, and that would actually be the buyer that would sign off on that. So let's talk real quick about the NHD industry. What we know over the 45 years that we've been doing this, we know that all reports are not created equally. There's no barrier to entry because we're unregulated. We've seen NHD companies, they've been here today, so to speak, so they've come out and then they've been gone tomorrow. So anybody can do NHD, anybody can give these kind of disclosures and determinations, but the question remains is, are they doing it right? It's not always about price. I know some of the competition offers better prices than us, but it's really about quality. What are you actually getting with the NHDs that come through, whether it be commercial or residential? And really why? Because your reputation's on the line. So I want to make sure that you guys have a great reason for choosing the company and report that you give to your buyers. Let's talk about NHD then. Let's talk about the statutory seismic zones. So with that, we have Alquist-Priolo state fault zones. And that came out at 1972, and the first maps were actually issued in 1974. And then we're also going to talk a little bit about the Seismic Hazard Mapping Act of 1990, which required the earthquake-triggered liquefaction and landslide zones to then be disclosed. So let's talk about LA County, okay? When it comes to LA County, there are quite a few fault lines, right? We have, oh my goodness, the Northridge fault line, Raymond fault line, Santa Monica, Hollywood, Newport, Inglewood. There's a lot of individual fault lines, but the notable fault lines that we know of are what? We know of the San Andreas fault line, and we know of some of the other ones, such as, I think a big one would be the Northridge fault line as well. We also have additional risk of tsunamis in certain areas along the coast. And right now, there's about a 75% likelihood of one or more 7.0 quakes striking the Southern California region. Did you guys hear about the earthquake that just hit Japan? 7.4, right? Well, you know, these things happen. They really do. So what I want to do is I kind of want to do first touch on this, and then we're going to do a simulation of what that kind of earthquake would look like in regards to Southern California. So who remembers the Northridge earthquake? Was anybody around? Okay, I see hands going up. All right. Unfortunately, this was a pretty severe earthquake. As you can see, there's the overpass that toppled right there on the left. There's a parking structure that folded in on the left. And then on the right upper part, those were condominiums and apartment complexes that just fell apart. So that was a 6.6 quake. So it was strong, but they get stronger. I mean, imagine a 7.4 earthquake. I'm actually going to show you what some of the scientists in the state of California are predicting. This comes from the California Earthquake Authority, and this is a magnitude 7.8 scenario. They're saying the epicenter is going to be somewhere underneath the Salton Sea over by Bombay Beach area. That's where a lot of seismic activity is happening right now. If you go to usgs.com, you'll see that there's a lot of magnitude 2s and 3s happening consistently. So I'm going to start this simulation just for you to kind of get an idea of what it would look like in the event that an earthquake happened right there in the Salton Sea. This is going to be in real time. And at the bottom, this is the shaking intensity scale, or they call it the Mercalli Index. As you can see, the red's going to be the most severe, the white's going to be the least severe. So I'm going to start it, and there we go. We're about 12 seconds in, and I can guarantee you the dogs and cats and animals in Palm Springs are probably making some noise. Usually they pick up and sense these things before us. Now there'll be some rumbling in Palm Springs. Some potential. There is a lot of liquefaction, believe it or not, in Palm Springs. We're under a minute, and we're already up to the Riverside area, and it's just going through. So 55 seconds, we hit Riverside. About 60 seconds. So 1 minute in, Ontario's feeling it. Anna, Long Beach, Lancaster, Victorville, they felt it as well. But you can see it's just traveling right through the other fault lines that are associated and connected with the San Andreas fault line. And it goes all the way out to Santa Monica, out to the Pacific Ocean. And we're about 105 seconds in. So that's still less than 2 minutes. And believe it or not, Ventura, in under 2 minutes, Ventura is feeling this. So I don't say this to scare anybody. I say it because I want you guys to understand the potential issues that can happen in regards to certain earthquakes. So this is a 7.8. Japan just had the 7.4. So you can imagine what that looks like as well. Okay, so enough of all of that crazy stuff. Let's talk about the statutory seismic hazard zones in Southern California. Every quadrangle here in yellow is an actual fault line. That's a state fault line that's recognized, okay? Everything that's in blue and in red are either liquefaction or landslide zones, okay? So this whole section right here in the blue and the red are fault lines along with liquefaction and landslide areas. We're going to get more into this and kind of give you a better look as to why this area is blue, red, and then why the rest of the area is just yellow, except for this one little box here in Murrieta, which is red. Let's talk about this. So let's talk about what this looks like for LA County. In regards to landslides, that's going to be everything in brown. In regards to liquefaction, this is going to be everything that's kind of in the teal green. And then you can see the map's not available in other areas. Now, this is according to LA County. It is quite the anomaly, but in most areas, the funding to have a state geologist put this information together. So what they do is it says my internet connection. What this actually does is this allows the state to go ahead and say, we trust the counties and the cities to provide this information if it's available and if it's a material fact. Because if it's a material fact, do you guys think it needs to be disclosed? Absolutely, it does. So let's keep going. And we're going to go into flood zones. So FEMA special flood hazard areas, those would be anything that begin with an A or a V. A being inland, V being coastal. And then we'll talk a little bit about the dam failure inundation zones as well. So LA County, here we go. You're going to see everything that is in kind of the bluish purple is considered to be a state recognized flood zone or a FEMA recognized flood zone. So when a parcel or property falls onto one of these flood zones, that's when the flood insurance would be required as long as you're taking a loan out on it, just so it could mitigate the potential risk of loss for the actual mortgage holder. So let's take a look at this. I find this very interesting because I have good friends with the NFIP, the National Flood Insurance Program, and the FEMA Region 9 director out of Oakland. And we were talking about this, and I found it interesting because here's the city of Los Angeles. A lot of it's in an area of minimal flood hazard. You can see there's Beverly Hills, there's the city. You see everything in the blue is an actual flood zone. Everything in the brown is an area that is under evaluation to be introduced into a flood zone. And that's based upon different benchmarks that the city or that the county puts out. And then FEMA and the National Flood Insurance Program, they get together with their structural engineers and their surveyors, and they say, okay, well, this could be a risk. And if it is, then they take that whole section and they include it in the flood zone. Flood maps are ever changing. Usually they change anywhere between 3 and 5 years, sometimes even longer. But right now, FEMA is, well, last time I checked, over $23 billion in debt. And that's dating back to Hurricane Katrina. That's dating back, to many other disasters that have happened, including this pandemic. So right now, they're really looking at mitigating risk. What risks do they need to mitigate? And that's why they're adding more and more into the flood zones. So First American Natural Hazard Disclosures, we've got your back. And here's one of the ways that we're helping. Every NHD that you get from First American will automatically come with a free flood certificate. This flood certificate is produced by CoreLogic, and it's going to tell us where the flood zone is in proximity to the actual structure itself. So if you guys see where the arrow is pointing, under the comment section, it says the subject property is partially within a special flood hazard area. The existing structure, however, is not affected and not in the floodplain. So this flood insurance certificate could actually help ease. So we were talking about dam inundation zones. And here, this is LA County, and everything in the light blue is going to be considered to be a dam inundation zone. So what does dam inundation mean? That is the scientific mapping of where the water may flow in the event that a dam were to break. So let's pull up an example here. Let me see. Give me 2 seconds. See if I can get this slide to work. There we go. All right. So the Lower Van Norman Reservoir here. There was a picture back in 1971. There was an earthquake. It was the Silmar Earthquake. And what happened was that this dam, the Lower Van Norman Reservoir, was shaking so hard that it caused as you can see, this is a picture up in the front top. As you can see, it caused the the top of the dam to start crumbling in, and the water began to rise a little bit. And what was said by most of the scientific geologists and researchers that came out at that time is that if it continued to shake for the next 30 to 45 seconds, most of that water would have pushed through. And you can see down below all of that housing development, right? A lot of that would have been flooded. It would have been destroyed. And we don't even know how many lives could have been lost due to the dam failure. So that's why it's important. And that's why this is on the natural hazard form itself and why it's required. So little pop quiz here for you guys. All right. This is just to make sure you guys aren't sleeping. I need you guys awake. Anyhow, so the question is, we've got Folsom Lake's up in the Sacramento region. Back in July of 2011, you can see the locks were open. There was a ton of water in there. And then in January of 2014, it dried up. It was bone dry. So even though a dam might be bone dry, the question I have is the NHD disclosure still required? Yes, that's right. Everybody's shaking their head. Yes, that's right. And the reason why is what? It can fill back up, right? So it is kind of interesting. Sometimes we've had people say, well, there's no water there. Why do we have to notify people of this? Well, because there could be, and it can come back. It could always come back. So let's talk about another hot topic right now, and that's the statutory fire zones. So we have the state responsibility areas, the SRA zones, and then we have the very high fire hazard severity zones. One new word that has been coined from last year is mega fire, and this is a big word now in the fire section of real estate and insurance. But what does mega fire stand for? So one, it stands for an extraordinary fire. Two, a wildfire that burns over 100,000 acres. Or three, a wildfire that has an enormous population impact. Well, we've seen quite a few of those in the past couple of years, whether that be in Northern California or Southern California. And they've led to some pretty devastating circumstances for a lot of people. So statutory fire zones, here's LA County again. We have the state responsibility areas. That's going to be a wildland area, everything in brownish beige. And then we've got our local responsibility areas, which will be what your local fire department would respond to. And that's everything in the pinkish red there for LA County. And this is according to the state of California. Okay, so let's talk real quick about that recent fire history that we were talking about. It's interesting. We pulled some fun facts here, not really fun, but we pulled some facts up. And 16 of the top 20 largest California wildfires, now largest meaning acres burned, have occurred in the last 2 decades, and 5 of them just in 2017, 2018. So just kind of going back in it, and I'm sure you guys have heard about these, or you still remember them. Back in 2017 in Northern California, there was the Tubbs, the Atlas, the Nuns, the Pocket in Sonoma County. There was 160,000 acres burned, 40 deaths, and about 8,000 structures were actually brought down to the ground. In December, in Santa Barbara and Ventura County, there was the Thomas Fire, which burned 280,000 acres and 1,000 structures. And then following that, because of the fire, and the fire burned out the root system in some of these areas that could that were hilly and required that root system to hold the ground together and hold the soil. Well, we received a ton of rain that January, and in the town of Montecito, there became the Montecito Mud Flow, and it was downhill from the Thomas burn area. And if you guys remember that back in 2017, there were 23 people that passed, and that's because of that mud flow. And it again resulted from that big fire. So the fire didn't just cause issues with structures and all the acres that were burned, but it burned up that root system as well. And with the new rain introduced, it became even more devastating. 2018, there were 230,000 acres, 8 deaths, 1,500 structures up in the Shasta, Trinity counties and those areas. Back down here in Southern California in November, there was the Woolsey Fire in LA and Ventura County. And then 2019, Kincaid Fire. And then 2020, the data for this year is actually still being tabulated, and we don't currently have it. But once we do, we're definitely going to share it, because we feel like the fires are just getting worse every year. And there's many different reasons for it, but that's where a lot of people are focusing their attention right now, is on all the different fires that have happened and that continue to happen. So with that said, Assembly Bill 38, that came out at the beginning of this year. And this is really more for residential. But what it does is it adds a high fire hazard severity zone to the already very high fire hazard severity zone disclosure. It went into effect January 1st of this year, and it says that the seller must disclose high or very high zones if the home was built before January 1st of 2010. And then effective this year, July 1st, the seller must document that the property complies with the certain wildfire protective measures or local vegetation management ordinances, or get the buyer's agreement to comply with it, meaning that if they're not going to do it, the buyer is going to agree that they'll go ahead and update the property to comply with these ordinances and protective measures. So, city and county zones. This is really where the rubber meets the road for NHD, whether it be residential or commercial. So all California counties and cities are required to produce a general plan. The general plan is going to regulate the development through the local permit process. So let's say you're selling a home, you're on the buy side, you have some buyers that want to go build or do an addition to the home. When they decide to put in that pool or do that addition, build that fence, that deck, and they go apply for the permit, the city and the county that issues that permit is going to consult with the safety element of the general plan, because it includes all the detail for that parcel and the neighborhood level hazard maps. The local hazard zones, they're going to typically differ from the state zones, or they're going to address the hazards that the state maps don't cover. We talked about that a little while ago, where the state doesn't have all the funding to do that. So they require and they ask that the cities and counties provide that information. And that's where we pull it from, because if it exists, it's required to be disclosed. If it's considered to be material fact in a court of law, First American NHD, we've got you covered, because we are reporting directly from the safety element of the general plan. Let me give you a kind of a real world look as to what that looks like. So here's an example. It's the state of California versus the county of Los Angeles fire hazard zones. If you look up to the right, that's the photo I showed you before, and that was the state fire zones in Los Angeles County. But then if you go to the county, the safety element of the general plan, and look to the left, what do you see? You see a lot of stuff that was left out by the state, right? Well, that's where the county has the information. That's why it's important when disclosing to make sure that you're getting it from the safety element of the general plan. I just cannot express this enough, because not everybody reports from it. There's a lot of NHD companies out there, but you know, they may or may not be reporting from it. So my question, or my comment would be, is when you use your natural hazard disclosure company, make sure that they are reporting from the safety element of the general plan. And you can actually see that in the definitions page of where they received the information that they're providing. So this is what a First American NHD summary page looks like. So statutory, meaning state NHD determinations. You can see this property is not in any kind of a hazard area. And then we went to the county as well. No, it's not in any kind of an area as well. But, oh, I can't see the bottom here. I don't know if you guys can. Whoops. I don't know if you can see it, but the city, it says that it's not in a dam inundation or fault area, but it says it is in a very high fire hazard severity zone. And that's underneath right there. I don't know if you're able to see that. Unfortunately, my taskbar is not allowing me to see it. So, but it will show whether or not it's affected per the city, because the city's going to trump the county, and then the county's going to trump the state in the information that it has. Let's look at some more in LA County here. Let's look at the city ground shaking zones in the city of Long Beach. As you can see, there's a ground shaking 1, ground shaking zone 2, and ground shaking zone 3. Those are the different severity levels, and pretty much all of Long Beach is going to fall suit to one of those areas. And then look at Santa Monica. There's the city clay pits, landslide, and fault zones in the city of Santa Monica. So again, as I stated before, lack of state funds should not diminish the required natural hazard disclosures that can really be obtained through the safety element of the county and city general plans. Here's another one. Oh, this one, look at this. So the state shows that the only thing, according to this property, the only thing affecting it is that it's in a very high fire hazard severity zone. We went to the county of LA and they said, okay, well, we know that it's in a ground shaking zone and we know it's in a landslide zone and we know it's in an expansive soil zone. And then we went to the city and the city said, well, it's within 660 feet of a map fault line. The city said that. So can you imagine how upset that buyer might be if they find out that they have to hire a soil geologist now to come out and test the soil because the state didn't tell them and the county didn't tell them? And now it's going to cost $3,000 to $5,000, maybe even more for them to do that. Who are they going to be upset with? They're probably going to be upset with the seller and the seller's agent. So let's look at LA County as a whole. We know that according to the safety element of the general plan, LA County has fault zones, landslide, liquefaction, debris flow, hillside, dam, tsunami, fire, methane. And then all of the cities that are in LA County have their own little areas of concern. Pasadena has fault, fire. Monrovia has fault. Arcadia has fault, fire. San Dimas, fault. Laverne, fault, fire. You know, there is a ton of issues that continue to remain even though the state isn't reporting it. So whether it be commercial or residential, it's always important to make sure that everything is disclosed. And that's where First American comes into play. When you trust us to utilize us for your NHD report, we want to protect you. So we've been doing this for 45 years. And believe it or not, we've never once had to use our E&O insurance. I mean, we do carry 30 million in E&O and we would use it if we had to, but thankfully, knock on wood, we haven't had to do it yet. So let's talk real quick about a phase 0 report, and then we're going to kind of transfer it over and hand the floor to Ami. But this is something else that we've coined. We became the pioneer of the NHD environmental report. So back in the early 90s in San Jose, we had a brokerage come to us that recently had a lawsuit due to a leaking underground storage tank. And they came to our company, JCP, that's what we're known by up north. They came to us and they said, can you guys produce any kind of a report that can tell us a little more about leaking underground storage tanks and some other things? So we started taking a look at it. And we started taking a look. At that time, we owned a phase 1 company, and we worked with them to determine whether or not what would make the most difference to them. What would they need to know? So we started taking a list of all of these different concerns that were starting to pop up. And essentially, we created this phase 0 report that gives you a sneak peek into the potential environmental concerns, and really a good reason to consult with Ami as well. As you can see here, this property, it's in the bullseye, right? You can't really even see the property. There's a little bit of red in there, but that property right there is just littered with corrective action sites. So being a commercial or residential specialist, if you saw something like this on your phase 0 report with First American, this is where you're going to call Ami and you're going to say, Ami, I need more information on this. And then at no charge, I know Ami's going to talk to you. He'll consult with you. He's done it for quite a few of our clients now. And he'll give you more insight as into whether or not you need the phase 1 or phase 2 report. So with that said, I appreciate you guys not falling asleep on me. And I want to go ahead and transfer the floor over to Ami. Thanks for listening, guys.
Well, thank you very much, Stephen, and thank you for all the compliments. I hope I will measure up to everything that you said about me.
You have so far. That's good.
Well, thanks. So we'll take it from here. And let me just, so I don't get distracted by my own picture. Let me do something here. Yes, so I'm an environmental professional, and I'll talk to you about phase 1, and I'll talk to you about some differences between the phase 1 and the natural hazard disclosure. My personal background, since 1988, I've been doing phase 1 and phase 2 environmental site assessments as myself and as a company. And at one time we had like over 20 associates, and we still are up and strong. And we did a lot of contamination cleanup. We still do contamination cleanup, and we give it free introductory consultations. Back in from 1988 to 2018, we removed a lot of tanks. We removed about over 2,000 tanks. We built gasoline stations. We demolished gasoline stations. We know a lot about tanks. We, as I said, removed thousands of these tanks and we installed over 40 gasoline stations. So when it comes to underground tanks, we think we know what we are talking about. Between 1988 and now, we did a lot of site investigations, what is called phase 2 site assessments or site assessments. You see all these machines that we are doing on the upper left right. There is a big drilling rig. We use it to install wells, monitoring wells into the ground. Down below on the left, you see us searching for tanks which are buried in the ground. We use these electromagnetic devices to look for the hidden tanks. In the bottom middle, we are inside an industrial facility drilling down to groundwater to take samples of the groundwater. Bottom right, we are drilling by hand. Sometimes we do it by hand when we don't have to go deep to take samples from a site that we just did recently. And on the upper right here, we take vapor samples from the soil. We had a fleet of 6 machines that we were going around and extracting gasoline from groundwater. We had quite a few sites where gasoline was floating on groundwater or dissolved in groundwater or even in the soil. And we use these machines to go around and suck out the contamination. In 1964, I graduated with a BSc in mechanical engineering and additional credits in nuclear and chemical engineering. And the next 8 years I spent in nuclear facilities doing construction, doing operation and maintenance of nuclear facilities. From there I moved to refineries. From there I moved to chemical plants. This one is a chemical plant down in the Dead Sea in Israel, 400 meters, or about 1,400 feet below sea level, sometimes working at temperatures exceeding 130 degrees Fahrenheit. So it was a fun. And after I moved to the United States, we did a lot of chemical plants here. Here is one US borax in Boron, California. If you ever go by this place, I think they have the largest quarry that I have seen in the world, going down and to extract this borax material. I have, my company and we have a license as general engineering contractor, and that enables us to build everything, even skyscrapers, except we specialize in the removal of hazardous substances. And we have this special certification, which is hazardous substance removal. So I'm telling you this so that you know that when we talk about hazardous substances, contaminated material, we know a lot about it because we actually removed it with our own hands. Here is a site that we finished recently. It's in Silver Lake, California. You see here all these piles are hazardous material. This is pesticide contaminated land that we excavated and move out about 1,000 cubic yards of contaminated stuff. And right now they are putting a very nice apartment building there. So phase 1, environmental site assessment. What does it do? Even more important, what does it not do and how it came about? And how is it different than an HD? There is a certain background to it. And yes, if you have questions, always call me or text me or email me. You will find that I'm very available. It's a matter of importance for me to be available to you for all questions. You can send me reports that you get and I will go over them with you. Here is my phone number, 323-899-5001. Email, it's amia@amiadini.com, or simply go to the website. Just remember my name, Adini, one word, and amiadini.com, and go to the website and you will find me there. The background for phase one, environmental site assessment, there is a certain history about it, how it all started, how it all came into being. And it began in 1978 in a small neighborhood in northern New York state, known as Love Canal. And it was making headlines after it was revealed that the site had formerly been used to bury 21,000 tons of hazardous waste. So we had this community sitting on 21,000 tons of hazardous waste and didn't know about it. But what they did know is that they had high incidence of birth defects and many anomalies, such as enlarged feet, heads, hands, and legs, abnormal incidence of miscarriages. So this was kind of weird and very unfortunate, and they started investigating it. And Love Canal was declared an unprecedented state emergency on August 2, 1978, and on August 7, 1978, United States announced the federal health emergency because of this thing. As a result of the emergency, the government relocated more than 800 families and reimbursed them for their homes, and the United States Congress passed the Comprehensive Environmental Response Compensation and Liability Act. So this was kind of a major trauma and a major wake-up call in the life of our nation to become aware of what hazardous waste and neurotoxic materials can do to residents that they are not aware about them. The Congress passed this law. In short, we call it CERCLA. It stands for Comprehensive Environmental Response, Compensation and Liability Act. And they passed it in 1980 in response to this unfortunate event in Love Canal. And the idea was they realized real quick that all over the United States, we had many of these landfills that we were not aware of, and that we needed to clean them up. So they passed this law and said we need to clean them up, and they put a special tax to fund a trust fund of $1.6 billion. $1.6 billion was a lot of money at the time, and this is why the law, and this is why the law became known as a Superfund. And they use the money to investigate, clean up, or abandon this hazardous waste site. The US EPA received the primary responsibility for managing the cleanup under this law, under CERCLA. And the way it was that the EPA, because it was an emergency act and many of these sites had to be cleaned up in a hurry, so the EPA had the authorization to move forward and start cleaning it up. And they were authorized to pay for the cleanup when the parties responsible for the contamination could not be located right away or were unwilling or unable to perform the cleanup. But then again, our government, sometimes they do things for free, but many times they don't like to do it for free. And they wanted to be compensated for this work. And so the EPA can take legal action to force responsible parties to clean up the site or reimburse the government. So if they don't move on their own, the EPA move, and then they make them reimburse the government for the cleanup. And so how do they do it? They invented the law, invented the thing or the term called potentially responsible party. And potentially responsible party is any individual or company, including owners, operators, transporters, or generators that are potentially responsible for or contributed to the contamination. So the idea here is that the government does not have to prove beyond a reasonable doubt that you or I are responsible for it. All what they need to do is say, well, we looked up the case and we find that you are potentially responsible, so therefore you have to pay for it. And you can go after us and you can tell us that you're not potentially responsible, and the burden of the proof will be on you, not on us. So as you can see, it was a pretty onerous law. because they needed the money to clean up the land. The law invented also, not invented, but they assigned what is called joint, strict, and several liability. Liability means what you have to do, what you are responsible for. And so any of these potentially responsible parties would be jointly, strictly, and severally liable for the contamination. And let's see what it means. And again, let me make a disclaimer here that I'm not a lawyer, but I'm just giving you my simple layperson understanding of joint and of this terminology. So joint and several liability means that you have a group of potentially responsible party where everyone and each one can be made responsible. So what it means, and it has been done frequently, is the EPA make up the list of the potentially responsible party, and they have a list of about 100 of them. And they look at the list and they say that you and me look like we are the deepest pockets. We are very rich people. We have a lot of money, and therefore we can carry the burden of the cleanup. So the EPA says, okay, we go after you because you are strictly and jointly liable. We can go just after, we have 100 responsible parties, potentially, but we decide to go after those that are the easiest for us to go after them. And we take it, so this is what it means, joint and several liability. But not only that, there is also a strict liability here, where you can be liable without fault. You don't have to have a motive, you don't have to be at fault. For example, let us give a real example. You are a transporter and you were retained to take hazardous waste from my site to take it to a landfill. And you only transported it. And now the government wants to clean up the landfill. So first they go after me because I am the source, but then they go after you because you used your trucks to carry the hazardous material from my place to the landfill. So you were a transporter, you are not at fault, but still you contributed to it in the eyes of the law, and they can go after you. So this is strict liability. Also, it could be a case where somebody, let's say, assume a dry cleaner, because this is kind of a problem of the day that we talk a lot about them. So dry cleaners. So let's say there was a dry cleaner in the 1940s in a certain properties, and they stopped operating in the 1960s. For 20 years, they sat there and they contaminated the area. And then they moved away and somebody bought the property and they redeveloped it to a residential, and then somebody else bought it and somebody else bought it. And eventually in 2000, or maybe let's say in 2000, you bought it, and in 2010, you sold it to somebody else. And but now it is found to be contaminated. It has to be cleaned up. They can go after you because you are on the chain of ownership of this place. You don't have a fault. All what your quote unquote fault is that you are on the chain of ownership. You did not cause the contamination. You did not even know about it, but you were the owner of the land at one time. So this is, there is a strict liability and you can be held to pay for it. So this was pretty onerous. And the real estate industry came up with a big cry and they said, this is not fair. And the government listened to it. And in 1986, they created the Superfund Amendment and Reauthorization Act. And what it did, it provided the innocent landowner defense. So what it means, if you bought a property, you did not know it was contaminated, and you did not cause the contamination, you did not know it was contaminated, it will take you off the hook. It will take the responsibility off your shoulders. And but then you had to prove, in order to get the landowner defense, innocent landowner defense, you had to prove that you had no knowledge of the situation. So the question was, how could you prove something that you did not know, like proving a negative, right? How do you show that you did not know? So The government said in the law, so in order to get the innocent landowner defense, you have to conduct all appropriate inquiry. So they tell, if you show us that you did all appropriate inquiry before you purchased the land, and you did not know, after doing all this inquiry, you did not know about the contamination, you are home free. Except the government being the government and the lawmakers being the lawmakers, they did not define what all appropriate inquiry is. They just said you had to do all appropriate inquiry, and this will take you off the hook. So there we were in about 1988, 1986, the law came about, and this started the whole industry of phase one. Around 1987, it started. We moved into it, myself and my company. We moved into it in 1988 in the very beginning. And the process, the all appropriate inquiry, then took the name Phase One Environmental Site Assessment. This is where the name came from. And for the life of me, I don't know who invented it. I don't know how it came about, this name, Phase One Environmental Site Assessment, which is a name for the all appropriate inquiry. If anybody of you will ever find about it, please let me know. I would really like to know about it. When we started doing it in 1988, the real estate, phase one consultants at the time were charging in the range of $5,000 and up to do a phase one environmental site assessment. And it was pretty expensive. And the real estate industry could not tolerate this kind of cost. It was too high. So, and here is an example. We moved into it in, as I said, in 1988. This is the city of Arcadia, and this is the Embassy Suites Hotel, and next to it is a Marriott Marriott Suite, I think, hotel. This is the area of 1 acre here. And we cleaned it up in 1988 for city of Arcadia. At the time, it cost them about $1.5 million. And we did it in a hurry. In today's money, probably would be about $3 million or more to clean it up. We, in 1988, Texaco USA, they had a big judgment against them, and they had to liquidate a lot of oil and gas properties in order to pay for the judgment, and they retained us to do the phase one environmental site assessment. But then again, it was 1988. We did not know what it was. We knew that we had to do a phase one environmental site assessment, but there was no definition. And we moved in and we did 72 oil fields at the time, and we basically invented the phase one process as we went along. Here is another case in the city of Anaheim. The entire civic district there, it's about, we were retained in 1988 to do this phase one and research all the property around if there were any liabilities of hazardous waste. And it's about 500 properties, residences, commercial, industrial. We found a lot of tanks that nobody knew about them. We found some contamination there. And we were engaged in it for about 5 years, from 1988 till 1993. But then again, we were inventing it by the go. We were inventing the phase one process. So in the early 1990s, because it was such a wild field, the ASTM, which is the American Society for Testing and Materials, and they create a lot of national and international standards. They moved in with the goal to create a standard process for the phase one. And they created the ASTM standard E1527, which is a standard practice for environmental site assessment phase one ESA process. And this began to put some order into our industry because it told us what we needed to do in terms of phase one. And here is the first page of the standard practice E1527 for site assessment, phase one environmental site assessment process. And this is a very meticulous and standard that it's a very good standard. It tells exactly what needs to be done so that we give you or your buyer or your seller the innocent landowner defense. But not only that, in time, the entire financial industry, the lenders became acutely sensitive to transacting with properties they had no liabilities. And they adopted this phase one process, which originally was designed to protect against the surplus, the Superfund liability, against the EPA liability. They adopted it as an overall standard in the industry so that they will not incur liability of contaminated properties. And I can explain a lot more about it if anybody of you would get interested in the details, the technical details or legal details of it. So right now, the entire industry works with this standard. And it's being used now for all transactions with commercial and industrial properties, and sometimes even residential. As I speak today, I'm doing a property in Santa Barbara, which is 2 apartment buildings. And for some reason, the lender is insisting on doing a phase one environmental site assessment. This is kind of unusual, but it happens. So major difference between the phase one and environmental site assessment and NHD is that NHD is required by law. Interesting, what Stephen told us today, which I was not aware of, is that the NHD industry is not regulated. That means anybody can do NHD. The phase one environmental site assessment is not required by law. It is a good commercial practice. All the lenders demand that it's being done. And most buyers nowadays of commercial or industrial want it to be done, but it's not required by law. It is a good commercial practice, except the practitioners like us, like me, that do the phase one, we need to have certain qualifications that are defined by the United States EPA. So what we seek for, what we are looking for when we do this phase one environmental site assessment is what we call recognized environmental condition. And because we had to define, for the industry had to define what it is really the thing that we are concerned about, because we can, if we start sitting there and worry about contamination, it is endless. We can worry about any microbe in the ground, any molecule, and how far do we go in worrying and being concerned about contamination? So it had to be defined. And they defined it in a terminology which is called recognized environmental conditions. It's a pretty, very complex definition. It says the presence or likely presence of any hazardous substances or petroleum products in, on, or at a property. 1, due to the release to the environment. 2, under conditions indicative of a release to the environment. 3, under conditions that pose a material threat of a future release to the environment. And I can tell you that every time I read it, and I've been reading it now since 1990, I'm getting a headache, okay? Because this is a typical definition that is written by, I think, by attorneys. And at one time I sat down and I broke it up to, here it is, 36 separate definitions, okay? But the long and short of it, the simplicity of it, is that in recognized environmental conditions, we are looking for hazardous substances or petroleum products. We are looking for their presence or likely presence. Can they be there? We are looking for conditions of past, present, or future release that generally present a threat. All these releases that we are concerned about it, would it generally present a threat for human health or the environment? So not every release, not every pint of oil that you spill on the ground presents a threat to human health or the environment. Not every poison even that you put on the ground, it presents a threat. So we have it is part of the definition, it has to present a threat to human health or the environment. Last but definitely not the least is is a condition that generally would be the subject of an enforcement action if brought to the attention of appropriate governmental agencies. And I put here the policeman with a club because I think that this last condition is one, it's a very important one, because in my practice, it happens to me a lot that we investigate a property and we find some contamination in it, and the interested party is asking me, well, Ami, is it bad or are we home free? And I'm telling them, look, it is not bad. It's very light contamination. It is not a problem at all, in my opinion, and this is my opinion. It's not a problem, but you need to know that if you ever ask a government agency to give you a clean bill of health, and kind of unfortunately it is that quite a few lenders, if you go to them, they tell you, you have contamination, we want a clean bill of health from the government because before we give you the loan. So once you go to the government to give you a clean bill of health, once you go to the regulatory agency, you begin a process which can take you sometimes 2 years at least, and can cost you, in my experience, probably starting with $100,000, just so they will tell you that what Ami told you is correct. And so I told you in the beginning it was not a problem, but the bank wants you to get a clean bill of health from the government agency, and it's going to cost you money. So this is why when we face this situation, we'll tell you, look, we think it is not a problem, but if you go to the government and they will start their enforcement action, by the time you get clean out of it, it's going to cost you $100,000. And this is we have to make you aware of it, and we call it a recognized environmental condition. Here are some examples of such conditions. We do a phase 1. This is a strip plaza. We move in, we see this oil on the ground. This is, right away, we declare it is a condition. Here is another site, used to be a gasoline station many years ago. We removed the tanks, we cleaned it up, but here is a diagram. This is where the tanks used to be in the patch here. We cleaned it up, but here is on the left, a conceptual diagram. Here is the tank, and it leaked down. And we cleaned it up, but and we got a clean bill of health from the government, but there is still contamination in the ground that was left after we removed the tank. So we say, look, the government will not go after you, but once you redevelop the property and you excavate it down, be aware that you will encounter these hazardous substances there, that you will need to take them to a landfill, and it's going to cost you money. And this is hazardous, this is a recognized environmental condition. Here is a case that we had involved in city of Culver City, a school site, and they excavated. You see here in the dashed red line, this is contamination that they encountered there. And right away, they had to stop all the construction and take it to a landfill. So it became a kind of a costly item for them. Here is another case. This is in Northern California, close to Portland, close to Oregon. And this is in Redwood City. Our client owns this property, which is in the red square. And it is an area where the water around here, you see all around here, there is water, and it's contaminated because it used to be a lumber production facility here. They were getting all the redwood here and processing it, and they used a lot of pesticides and other poisons to kill up all kind of bacteria in the lumber. And so this is it went into the ground, it went to the groundwater, and our client is sitting here, and we tell them, look, you got a condition because this contamination most probably moved under your property here. Here is another case. This is close to Beverly Hills. Beverly Hills is on the left, where you see all these dark spots. This is the Beverly Center, and the entire area used to be an oil field, oil production at one time. Lots of oil wells. All the black spots that you see here are oil wells that have since been abandoned. And our client is sitting here as a yellow patch, and they are sitting on oil wells, on old oil wells that have been abandoned, but they are leaking. And these are recognized environmental conditions. The regulations, EPA regulations say that those that do this kind of investigations have to be environmental professionals. And EPA has a very long definition as to who is environmental professional that can do the phase one. And so there again is a difference between us and the NHD, because anybody can do NHD. It's not that I'm putting NHD down. It's very, very important, and they do a great job. But as Stephen indicated, you need to search for, you are on your own in deciding who is qualified to do your NHD. In our case, the EPA give us a very defined way as to who is environmental professionals. And I am very happy to tell you that I am an environmental professional by the definition of the EPA. And then we have the user of our reports, and the user of the phase one could be anybody, basically somebody, an acquirer of a property, a potential tenant, an owner of a property, a lender, a property manager, anybody. I mean, anybody can ask us to do a phase one. You walk down the street, you see a property, you want it, you don't even talk to the real estate agent or broker yet. You're just interested, you call us, we do a phase one environmental site assessment on this property, and we don't even tell the property owner that we are doing this investigation. The only limitation might be that we will not be able to enter into the property, but we can fly over with a drone, and we can get a lot of information even without entering the property. Let's skip this one. A component of the phase one is, or not a component, but one of the limitations, if you wish, is that it has to be done after a year. You do it, it's good for a year. After 1 year, you have to do it again. Very important component of the phase one is interviews. We do not interview face-to-face nowadays, I mean, the COVID, Corona, and we found it much more efficient to do it by mail. We send questionnaires out to interview the owners, the operators, the occupants of the property. And here is, we ask them for all kinds of documents, like 25 different documents. Just some examples, if they have any previously environmental site assessment done, any material safety data sheets, geotechnical studies, any notices from government, anything that will enable us to understand the property well. We ask for these documents from them. We search for environmental cleanup liens. We search thousands of documents of government records, and our research go all the way to the times the property was first developed. So sometimes we can go to the late 1800s until the time it was first developed. This is how far we go with our research on the history of the property. We use aerial photography. You see those aerial photographs. Usually they go up all the way down to 1920s. And we use topographic maps. We have them all the way down to 1890s. And we use city directories. Old city directories, historical, in my experience, they go all the way back to, like, I can get them back to the 1940s. And they give us a lot of information about the historical owners of the property and the surrounding neighbors. It's very important for us to know who is around. And here is an example we get on this property, 2205 Durfee Avenue. It's not the property that you investigated, it's one of the neighbors. And city directory is telling us 1957, it was a shell service. 1966, it was a mobile station. 1994, it was a body shop, and so all the way up to present time. So those city directories give us very valuable information. We do the electronic data search of databases. As Stephen indicated, that they do this research on 16 government databases. We do it over 130. All right, so that's another major difference. We search 130 government databases all over, and we get those maps, and you see all these red triangles and the black squares. They indicate properties that can create a problem for our property. Our property is sitting here in the bullseye, the green rectangle in the bullseye. This is our property that we investigate. The rest is in a radiuses up to a mile around it, all these guys that might present a liability to the property. And we go and investigate, we research each one of these points that you see here. I click on it and it opens a drop-down menu, and I get a lot of information on each one of them. And we really do this very heavy research, and that's again a difference between us and the NHD. NHD will give you a similar map with the dots about it, and like fire hazard or earthquake hazard, they will tell you you are in this zone. But if you want to know really what your risk is, you need to retain a soils engineer, you need to retain a geologist, etc. In our case, we do this research already. We research each and every one of them, and then we create these tables, and each one of these properties that you saw flagged over there, we make our comments on this property as to how closely or how liable or how possible it is that they will contaminate our property. We look if the property is in a transaction, we ask the seller, how much do you want for it? We ask the buyer, how much do you want to pay for it? If the purchase price is much lower than the property is valued, for example, they are offering it for $700,000, and we know that the value clean property is about $5 million, right away we suspect that there could be some contamination here that reduces the value of the property. We do extensive visual inspection, and we record it by photographs. We look into every nook and cranny inside the property. And that's again a difference between us and NHD, because NHD does not go into the property, we go there. Not only we go there, we go around all the neighborhood and we take pictures. You see here, this could be like 400 pictures that we take from the property and the surrounding properties. And then we produce a photo log, and here is a map. The upper right, you see this is all the arrows show the pictures that we took from all the neighboring properties. Our property is here in the yellow here, and everybody here is a neighbor, and we take picture of them because we want to see how possible it is that they impacted our property. Down on the left here, you see the pictures that we take inside the property, and then we produce our photo log, our photographic log with all the pictures that we have selected from the 400 pictures. Usually it's about 40 pictures or so. And then we issue our report, the phase 1 environmental site assessment report, and we give you an executive summary. We don't expect you or your client to read it. Just the report that I issued 2 days ago had 2,200 pages, 2,200 pages for a report. It's another difference between us and NHD. NHD is, I don't remember how many, 3, 4, 5 pages of report. Ours, it could be like 2,200 pages of a report. We don't expect you to read it. We give you an executive summary, and then we give you, in it, we describe our findings, we give you our opinions and conclusions and recommendations as to what you need to do or what you have on hand. And basically, I think I'm running out of time a little bit, so let me skip this. And here are some examples of properties that we handle. A consultant did a phase 1. This is an apartment building here, and they did a phase 1 on it, and they said, okay, there is a dry cleaner here, and they may have contaminated the property. So they retained us to do a phase 2 and tell them how bad the problem is. And we did a phase 2. We went around the property here. This is our apartment building. We went around it and we took samples from the soil vapor, and we found out that the soil vapor was contaminated. They were sitting on this cloud of contamination that migrated from the source point under this apartment building. And this was the bad news, quote unquote, but the good news was that the contamination levels were not that bad, and we gave them a clean bill of health. Let's move a little bit further. Here is another example of this strip plaza here, and they found that there were groundwater under them was contaminated, and it was contaminated. There is a dry cleaner here that they discharged their stuff, their solvents into the ground, and it went down to groundwater and it migrated into our property here, and it became contaminated by the cause of this property here. And they couldn't find us the property, so they retained us, and we moved in and we proved beyond a reasonable doubt that the culprit was here on the corner. They did not cause the contamination. Yes, they were sitting on a contaminated groundwater, but they did not cause it. Now, a phase 1 report would indicate that this property is sitting on contaminated groundwater. Then the bank or the lender or the buyer would ask them to do a phase 2. And we did the equivalent of a phase 2 here, and we proved that they were not contaminated. So I think I'll skip this one because we are running out of time. And but I can talk to you a lot more about these cases. If you call me in person, we can discuss it. So let's skip this. What in a kind of a conclusion, I wanted to present to you just that the phase 1 process is going to cost you anywhere from $1,800 to $3,000. Depends on the size, depends on the complexity of the property. If you need to do a phase 2 process, it will going to cost you anywhere from $6,000 to $20,000. Again, depends on the complexity of the situation. And industrial properties, it will cost you much more. And time-wise, time schedule, phase 1 report, we like to do it in 3 weeks. If you need the phase 2 report, it takes another 3 weeks. All the rest of the times in between here are usually in negotiations between seller and buyer and broker, because once we issue the phase 1 report, if we indicate that there is some concern, then they start negotiating, and eventually they say, well, we want or we don't want to do a phase 2. If they decide to do a phase 2, then we do it, and they start negotiating it again. And eventually, in our experience, it can take anywhere from 20 to 28 weeks by the time they resolve all of the concerns that we raised in the phase 1 and then resolved in the phase 2. So my advice to you is do the phase 1. It's better if you do the phase 1 well before you open escrow, so you don't get into the time constraint when your escrow is already open. All right, so the great aim of education is not knowledge but action. This says Herbert Spencer, and I hope that what Stephen and I has just told you will enable you to take more action. Knowledge is important, but knowledge without action, it's futile. So we'd like you to be able to take action. And both Stephen and I are available to you for questions now or later. You can take our phone numbers, you can take our emails, and feel free to contact us anytime. I know that Stephen will be happy to talk to you, and I sure will be happy to talk to you or email or any time that you wish. Thank you very much for being such a good audience, and we'll take it from there.
Thank you, Ami, and thank you, Stephen. And now we have some questions, and some of those have been answered, and I'll start from the top. And the first one, let's see, Frankie Ho asked, does the company, the question was for Steve, does the company work on termite inspections and corrections? And that was answered later, and no, but we can have Brandon assist with some referrals. Okay, now the next question I saw, what is the difference between ground shaking 1, 2, and 3? And then again, Stephen addressed it. It's ground shaking is based on the level of severity in or around the city of Long Beach. And if we want a little more detail on that, we can arrange it. You know, we can set up another date so that he can cover that, or on a personal basis. And let me see what other questions we have. Okay, Joanna Ling asked, besides the environmental inspection, you also do the cleanup to remove the source?
The answer is definitely yes. And we just a few months ago, we finished the cleanup of a property in Silver Lake, California, where we removed 1,000 cubic yards of contaminated soil. Right now, we are working on another property where there is soil vapor contamination there, and we are not cleaning it up, but we are doing what is called mitigation. We are installing special systems that will protect the occupants of the building from the toxic vapors. It's very important to stress that cleanup is not always needed. And I've run in quite a few cases where prospective clients started to clean up or thought that they needed to clean it up, and I stopped them. I said, no, you don't have to clean it up. There are other solutions. In one case, we spent $1.5 million already, and I stopped them, you know. I said, you don't have to do this. And so we need to look into every case. It's a very, very good question. Yes, we do clean up, but if we don't need to do cleanup, if there are other solutions to it, sometimes you can leave it in place. Then we show you how to do it. And everything, of course, is legal. We don't do anything under the table.
Okay. Also see the questions that Ami answered along the way about who pays, how much is the phase 1 and phase 2. He did give us that information as well. And Joanna asked another question, and this will be the last question. How do you handle if the source belongs to the owner, to other owner?
Oh, okay. Well, if the source of the contamination is a previous owner, not the present time, not the current owner, well, then you need to retain an attorney. And then the attorney probably will retain us or somebody similar to us to help them go after the responsible party. All right. But yes, that's getting complex after that.
Okay. And now, well, do we have time for just one more? Since
yes, right.
Okay. So the last one here, it says, who and when do phase 0 report? And thank you, Stephen. Thank you, Ami.
Who and when? So the phase 0 report or environmental report, we never have a charge for our NHDs until escrow closes, but I think it's good to get it at the time of listing, just to make sure that if there are any questions, you can look at it, you can say, okay, well, there may be a question that's going to result from this, and let me go ahead and get more information. So whether that's calling me for a little bit of it or talking to me, you know, I know he's there to help consult with you as well. I always recommend get it at the time of listing, because if you wait too long, you may run into an issue for sure. So,
and I want to reinforce this point, because many times we get those requests too late. Okay, they're already in escrow, and now everything comes to a halt. Everything stops. You see, and nobody knows what to do. Do it well before, and I know that on my end, and I'm sure Stephen as well, I'm always available to you. I can take a quick look at the property, and I have certain availability to certain resources, and I can look at it and I can tell you right away if there is a potential for a problem there. I will not be able to guarantee it, you know, because I need to do my extensive research, but at least I can look into it and say, well, I think you should expect a phase 2 here. The other day, I got a site like this. As soon as I took a look at it, I said, I don't need to do a phase 1 to tell you you need a phase 2 here. This property is likely contaminated. When I got a call from the client that I'm working for right now, that I'm doing these 2 apartment buildings, my first question to him was, why do you do it at all? You know, why do you do for the phase one? I was trying to dissuade him, to convince him not to do the phase one. And, and he said, well, I don't have a choice. The lender is requesting it, you see. So yes, call us well before you open escrow.
Thank you very much to both Ami and Stephen for all the information. Please use them on your next transaction. They're available for our information here for your clients, future clients as well, so they can be well informed. And thank you both very much for covering this for us.
And thank you, Sylvia, and thank you, Pauline. And I wanted to commend this organization, the West San Gabriel Valley. I think it's a very, very good organization. You are very well organized, and it's always a pleasure to give presentations and also to view your presentations. I think you are one of the better ones all around in terms of organization, in terms of presentation, in terms of how you present it. So thank you very much. It really makes me feel good to contribute.
I would agree. I think you guys have had great attendance. You can tell that your members really do pride themselves on education, and I appreciate that. So thank you for coming, and we appreciate it.
Thank you.
Great. Thank you, Stephen, Ami, and Sylvia for this great session. We appreciate your professional knowledge and disclose, but action. I remember. Please support our affiliates for the transactions. On behalf of West San Gabriel Valley Realtors, we do appreciate and thank Mr. Ami Adini and Stephen Strickland for your wonderful and valuable presentation today. Our next class will be March 2nd, Tuesday at 11 a.m. What is the topic? Very important. 2021 new tax updates and how Biden new tax policy will impact real estate. Don't miss out this great session by speaker CPA Jeff Huang. Please register all the classes at wsgvar.com. Choose education schedule. Register and join together, learn, and let's grow together. Stay safe, healthy. Thank you again, Stephen, Brandon, Ami, Sylvia, Fong, and all of you. We see you on March 2nd at 11 a.m.
Thank you.
Bye-bye.
Bye-bye.